So, my topic, if I understood it correctly, is what are the extent and limits of the judicial review of an arbitration award when challenged by an action for annulment on grounds of violation of public policy? Is the state court bound by the factual findings of the award, or is it free to reassess the evidence and potentially rule differently? I will constrain myself to Greek case law and theory, knowing, however, that in other countries, for example, Germany, another approach is taken. And as far as Greece is concerned, I will refer to a Supreme Court judgment, number 1514 of 2021, so a recent judgment, which has not taken the publicity which in the past the relevant corruption and money laundering decisions of the Supreme Court have taken, but which, in my opinion, puts the issues which are interesting here, all the issues on the table. The facts of the case. Company A was awarded the contract of a public works project. In this context, A assigned 50% of the works to Company B by virtue of private subcontracts. After executing the project, B received the agreed consideration. However, on account of the project's poor workmanship, the project owner, a local authority, requested a refund of an X amount from A. A took the view that such poor workmanship was B's fault and thus forfeited B's performance bonds in order to cover the X amount it was requested to refund to the project owner. B argued that the poor workmanship was A's fault and proceeded to request the arbitral tribunal to have the X amount returned to it. What was the arbitral tribunal's ruling? The arbitral tribunal found that the agreements signed between A and B were akin to a joint venture agreement, rather than a subcontract. According to its reasoning, after considering the special circumstances of the legal relationship between A and B, it emerged that A and B had directly participated in the project's financial result by 50% each, regardless of the works each of them had actually executed. Consequently, in the arbitral tribunal view, the loss ought to be equally shared between A and B. An action for annulment before the Court of Appeal has followed by B. B requested the annulment of the aforementioned award, arguing that it opposed public order. It submitted that the view according to which the legal relationship between A and B was a joint venture, was contrary to the mandatory rules of law governing public contracts, whereby the validity of the aforementioned relationship is conditional on strict factors of mandatory law, such as the project owner's prior approval. The Court of Appeal annulled the arbitration award after assessing the evidence and the parties' claim de novo. It ruled that the legal relationship between A and B was, and I cite the wording, essentially and actually masked as a joint venture agreement for the execution of the project, which could not be revealed to the agencies involved and was invalid as such. Consequently, the Court of Appeal ruled that given that the conclusion of such agreement was in breach of the rules of public law, rules on public contracts, the arbitral tribunal violated the provision of Article 897, paragraph 6, that is the provision dealing with the annulment ground for violation of the public order of the public order of the Code of Civil Procedure, of the Greek Code of Civil Procedure. The Supreme Court, Arios Pagos, subsequently found that the Court of Appeal proceeded to an impermissible retrial of the case on its merits, since it did not rely on the reviewed arbitral awards findings, but accepted an actual fact, namely the formation of a joint venture and the conclusion of an invalid contractual substitution within the project, which was not part of the arbitration award. I have here to mention that the Supreme Court of Greece did not deal with the issue, what is the meaning and the content of public policy in the context of the annulment ground I mentioned before. Thus, it did not deal with what the Supreme Court, by virtue of its decision 14/2015, has accepted, meaning that public policy is not consisting out of the sum of the mandatory rules of Greek law in the sense of Article 3 of the Greek Civil Code, but it is the public policy of Article 33 of Greek Civil Code, meaning the fundamental legal, economic, political, social, cultural, and moral standards in a jurisdiction. If it had considered the matter thoroughly, it would perhaps come to the conclusion that the non-consent of the owner of the work under public contracts law is not constituting a violation of the public policy as now redefined by the Supreme Court in order to create uniformity between what is public policy under the commercial arbitration law, international commercial arbitration law, and the domestic arbitration. So, what were the basic premises of the Supreme Court decision? The Supreme Court stresses that arbitral tribunals and ordinary courts represent parallel jurisdictional orders which are mutually exclusive. The Supreme Court adopts the view which prevails in case law, in Greek case law. Contradiction to public order must directly derive from the grounds and the operative part of the reviewed arbitration award on the basis of the facts of the case which were accepted by the arbitrator without further examination. The Court of Appeal, which hears the action for annulment, may only examine and judge on the basis of the findings of fact set out in the arbitration award. To adopt the opposite view, namely to accept facts and arguments which were rejected by the arbitral tribunal, is essentially akin to a retrial of the case on its merits, which overturns the finality of the dispute's resolution by the arbitral tribunal and the foundation on which the parties relied when agreeing on an arbitration clause. Thus, the prevalent opinion in Greek case law and theory is that the public policy control exercised by Greek courts over arbitral awards may not go as far as revisiting the merits of the case. The court is bound by the factual findings established by the arbitral tribunal even if these are obviously incorrect, meaning that incorrect findings of fact cannot trigger the setting aside of an arbitral award. An exemption is accepted in the sense that the Court of Appeal is not bound by the legal interpretation, the annulment court, is not bound by the legal interpretation and application of rules constituting public policy, which was adopted by the arbitral tribunal. This is subject to review. I do not want to mention every Supreme Court decision in this respect. I mention indicatively 13 of 1995, 40 of 2010, 517 of 2016, etc. So what are the arguments in support of this position advanced by case law and theory? First, what Professor Delis mentioned before, the principle of prohibition of revision au fond or prohibition of de novo review of the merits of the case. Secondly, the exceptional nature of Article 897 of the Greek procedural law dealing with the annulment grounds, in the sense that the grounds listed therein are exhaustive and in any case should be construed narrowly. The Greek Civil Procedural Code, as well as Law 2735 of 99, which implemented ancestral model law in Greek law, limit judicial review to vacate on specific grounds. There is here an absence of a ground relating to factual findings and misjudgment of the arbitrator. Evaluating evidence remains the exclusive province of arbitrators. Even a manifestly erroneous finding of fact, or one which is in contradiction with the case record, does not, as such, justify the setting aside of an arbitral award. Therefore, a reassessment of the evidence and the issuance of a different ruling, essentially overturning the arbitrator's ruling, circumvents Article 897 of the Greek Code of Civil Procedure. Another argument is that correspondingly, the Greek Code of Civil Procedure does not provide for an appeal of an arbitral award, which would allow the Court of Appeal to examine issues of fact from the beginning without deferring to the arbitral tribunal's decision. Reviewing with unfettered powers the arbitrator's findings of fact, as an appeal court is empowered to do in general, would be contrary to the spirit and purpose of the aforementioned Article 897 of the Greek Procedural Code, which aims at limiting the possibilities of setting aside arbitral awards by means of an exhaustive list of grounds, of annulment grounds. Arbitrators do not act as lower trial courts. They are not the anteroom of the ordinary courts, say, where subsequent appellate review is readily available to the losing party. Another argument is the principle, I think it was already mentioned by Professor Delis, of finality of the arbitral awards to which the parties aspired. Arbitration means the contractually selected and binding dispute resolution by arbitrators, as Supreme Court Decision 14/2015 also mentions. Another argument is the purpose of arbitration. The purpose of arbitration is to provide an expeditious and cost-effective dispute resolution procedure, allowing de novo review could open the door to the proverbial second bite at the apple, meaning a second hearing on the facts and law. Once that door opens, the cost of resolving the dispute could greatly increase, as could the time needed to decide the matter. Furthermore, the relationship between arbitral tribunals and ordinary courts is also decisive. They are parallel and equal jurisdictional orders which are mutually exclusive. Consequently, the judicial review of arbitration awards must be limited and clearly defined, aiming only at providing fundamental jurisdictional guarantees. A parallel is also chosen to Article 561, Paragraph 1 of the Code of Civil Procedure, where the factual findings of the Courts of Appeal are not examined in cassation proceedings. It is said that drawing such parallel is unfitting and unconvincing. However, case law does not apply 561 CCP in order to draw another argument. It rather gives an example in order to impart the quality and nature of the review. That is the first approach and the prevalent opinion in Greek law. The second approach...
Grigory, my apologies to interrupt. We're already, I think, at about the limit of time.
Only 3 minutes and I'm ready.
I will need to ask you to wrap up.
To accelerate.
We can move forward with
the second approach is based on some Court of Appeals decision focusing on corruption cases. I think Ms. Dimolitsa will perhaps say something about that. Where the opposite position was taken, that this decision affirmed that actually the annulment court is entitled to review the evidence and reassess the evidence and the factual assumptions of the case. The arguments in support of this second approach are the following. Existence of a review mechanism by national courts which guarantees fundamental principles of fairness. The question whether arbitrators comply with fundamental judicial guarantees is left to the state, acting as a guardian through the state courts. State courts are therefore entrusted with assessing whether the main legal consequences of an arbitral award contravene the most fundamental principles of justice. Secondly, the public policy clause is completely devoid of purpose, meaning review is impossible if the arbitral tribunal has misconducted the actual existing situation. We could discuss on that in order to save time later, perhaps.
Thank you.
And another issue is whether the violation of public policy derives from the operative part of the arbitral award or from the reasoning of the award, or from both. Both approaches here are implemented. The prevailing opinion is that it derives from the reasoning part and the operative part. Another opinion supports the thesis that only the declaratory part is decisive, because this issue has to be resolved at the end of the day within the context of enforcement and not within the context of the annulment proceedings. Last not least, I have to stress that the parties are free, if they want, to decide an appellate procedure within also the context of the arbitration procedures in order to address issues of, say, re-examining violations of the kind. Many thanks for your attention.
Thank you very much, Grigory.